this is a money issue for filmmakers. So it's really important because you can save clearance fees if your use does in fact qualify for fair use. So we want to make sure that we use it when we can. It saves a lot of administrative time, and then of course the licensing fees, if there are any. When we do fair use opinions, it's really part of a larger context of rights clearance. So today we're going to talk about fair use, which is principally focused on copyright and an exception to the copyright rule. But we may mention, but just know that there are other issues that we address as well, like right of privacy, right of publicity, defamation, use of trademarks, those sorts of things.
The law it actually borrows from a very old legal case, a piece of case law. And it says when you're using fair use, it's very abstract, it's very vague, and it's that way on purpose, so that you can fill those terms with your needs of the moment. It's a unique piece of legislation internationally. It says, when you want to use other people's copyrighted material while it's still under a limited monopoly, think about these things. What's the nature of the original work? What are you doing with that original work? How much are you using, and what's the effect on the market? If you want to make your life easier, think about those 4 things in this way. First of all, am I reusing this work for its original purpose? Am I making a substitute of that work for free to somebody without returning benefit to the original owner? Or am I doing something different with it? Am I transforming it, would be what the judges would say. That is a combination of the first and the second factors, the nature of the original work, the nature of the work that you're using. Then you would say, well, if I have a new reason, what is that reason? And how much do I need to make that reason, to fulfill that reason? You know, sometimes it's 100%. Say you're taking a photograph, you need to discuss the whole photograph. You might have a good reason. On the other hand, you might not need to put that photograph into your film in full high resolution either. Then the 4th reason, the effect on the market, is actually goes back to the transformative part. If you have a transformative use, you're not substituting the use. You're not just using the Beyonce song because people like to listen to Beyonce. You have something else to say, and because you will be using the appropriate amount, you're not going to be simply giving people the pleasure of Beyonce to watch Beyonce.
Everything that you're hearing, fair use, by the way, if anyone wants to actually look this up, it's 17 USC section 106. That's the, no, 106 is the actual copyright rights. And that tells you the monopoly of rights, because copyright is a bundle of rights. And so 106 says you can reproduce things, you can distribute things, you can copy things. Here's all the things that you can do being a copyright owner. And then the next provision is section 107. And it says, hey, here's how the fair use doctrine works. And it has a little preamble, and then it has the 4 prongs that Pat laid out. So those 4 prongs that lead into Dan saying, hey, you know, we make an analysis of these points, they're not rules, so to speak. They're guidelines. And so this is malleable, and that's why you want to get the lawyers or the experts involved before you're at picture lock. You can even have fun experimenting. Put it into your film. Say, like, this is what I want. And then, and you can keep it there through cut number 1, cut number 2. At some point, before you're at the picture lock, you're going to want to get confirmation that what you're using is appropriate. And I can tell you, Dan and I both are going to take the position that we want to help you. We want this to be a yes. So to make it a yes, we might give suggestions on how to make it a yes. It might mean you got to take some of that out. You're using too much. Prong number 3 is the amount. And so that's sort of how the process works.
The amount taken is both a quantitative as well as a qualitative issue. So to do a complete analysis, you might want to look at the original material to see, did you take everything from that clip? And also, are you taking the heart of it? In other words, the only thing that was really good in that whole analysis, or that whole original broadcast, was this one clip where he's saying something. and therefore this kind of goes to the impact on the market.
There's another attorney in New York who's the first person I heard kind of give this like little thumbnail trick. His name is Neil Rossini, so I want to give credit if anyone knows Neil. And he and I were speaking about this with regard to one of my early films, maybe 6 or 7 years ago. And he likes to use this trick that isn't appropriate for all uses, but I think for documentary filmmakers, this comes up the most, at least in my experience as a filmmaker and as a lawyer. And it's that the documentary filmmaker is most often trying to use a clip to make a point, to illustrate something. And so his little thumbnail trick is that borrowed material that's in your film, is the mere existence of it making the point? The fact that and that will come up in one of these clips. The mere fact that it's there, you as the filmmaker have achieved your goal because it has conveyed the message that you want to convey. Or is the material that's in there serving the film for its content? You're just sitting back and you're enjoying that piece. That's really funny, that's really good. And it's not in itself making the point. The mere fact that it's being shown by itself is not making the point. That's an oversimplification, but I actually think that for filmmakers who aren't lawyers, that if you can have that trick, that's a good, at least first threshold. Okay, I used this, and did the thing that I used make the point in the smallest way possible? Did I use just a little bit of it to get my point across?
I have been working on this issue, as Tom notes, since 2004. And the situation in 2004 was that every filmmaker was scared to death to employ this right because they were afraid of how much trouble they could get into. They were exercising a risk analysis, something you do all the time, without knowledge of actual risk. Today, and actually within months after filmmakers determined how they would interpret through their organizations fair use, this document came out in 2005. If you don't have a copy of it, it's on our website, centerforsocialmedia.org. You can pick up a copy of it or a postcard that will give you a link to it. Since that came out, since months after it came out, every single errors and omissions insurer in this nation accepts fair use claims worldwide, and now without incremental costs. Okay, who here does not know what errors and omissions is? Errors and omissions is the insurance that if you want to get on television or in theaters, you are going to have to get. Is insurance that says that if you made any mistakes in a number of legal areas, they are going to cover you. And every broadcaster, every cablecaster, every theatrical release will expect you to carry that insurance. Until this document came out, establishing what fair use means to filmmakers, to doc filmmakers, errors and omissions insurers were refusing to cover fair use claims. They would exclude them. Now, if your uses fall within this document according to a lawyer's opinion letter, a relatively easy letter to write because the lawyer doesn't have to say, yes, I think it's fair use. The lawyer only has to say, I think it falls within the terms of this document. Errors and omissions insurers will accept those claims and cover those claims should there be any problem. But when you employ fair use, you do not license, obviously. If you license the clip, you are responsible for all the contracts that the person who made the work made with other people. So if they did a SAG deal with an actor, and the actor gets paid something, and you license that, then you carry that same obligation. If you fair use it, you don't bring any of those contractual obligations to your use because you didn't contract with the licensor.
You don't have the contractual obligations. The question would be whether you're infringing rights or not, though.
We actually talked about the importance of this at lunch, and it hasn't come up. You use something for fair use in your film that does not give you the right to use it in promotion of your film, because then that's no longer a fair use. There's the discussion, is fair use a right or is it a defense? In other words, if I'm using someone else's material without licensing it, aren't I really a copyright infringer, but I have a valid defense to it? And there's different views on that. I can guarantee you Pat will take the point of view that it's a right. And I don't think she's wrong. The point that I want to make about that give and take is that no one is being in the wrong by exercising the right or exercising the defense of fair use. The bottom line is you have the ability to exercise it, and you're not doing anything wrong, you're not getting something by someone, you're not being undue to the copyright holder, of which you are going to be when your film is done. You're going to be a copyright holder of that film. So there shouldn't be a sheepish quality about it. I would say it's the opposite.